recognized for your opening statement.
Thank you, Mr. Chairman. Mr. Chairman, I want to start by expressing my deepest condolences to Laken Riley's family. The pain of losing a child is something no parent should have to go through. The alleged perpetrator should be prosecuted to the fullest extent of the law. By all accounts, Laken was a kind and gentle soul, beloved by everyone around her. May her memory be a blessing. Unfortunately, instead of coming together to express our sorrow for Laken's tragic loss, the majority appears to be exploiting her death for yet another partisan political stunt. Rather than approaching this tragic event in a thoughtful manner, Republicans appear to have just thrown together language from existing unrelated bills that target and scapegoat immigrants to score cheap political points in an election year, while doing nothing to address the situation at the border. This approach is fundamentally unserious. As if to emphasize the point, the author of this legislation spent the weekend promoting anti-Semitic memes on Twitter. At base, this bill is a rinse and repeat of the majority's unserious attempt to keep immigration in the news. Pick a crime, paste it into a template bill with sweeping, unrealistic immigration consequences. Then require detention and deportation of certain immigrants merely accused of committing such a crime. No due process required. All so that you can demonize immigrants and sound tough without actually making this country safer. The legislation before us today would subject to mandatory detention any undocumented immigrants merely arrested or charged with committing an act of theft, larceny, or shoplifting, along with those who are convicted or who admit to committing such acts. Let's think about that. Someone who is arrested, who was never charged with a crime, is now going to be subject to mandatory immigration detention? The case of Laken Riley is a tragedy, but as is often said, hard cases make bad law. Under this bill, committing a misdemeanor shoplifting, or even committing no crime at all, can result in a DACA or TPS recipient, someone who may have been in this country for decades, being subject to mandatory detention. Sadly, there are countless real-life examples of people getting arrested because of mistaken identity, through erroneous witness identification, biographical similarities to perpetrators, and errors caused by faulty facial recognition technology. In a markup we had in the Judiciary Committee last month, Mr. Massey discussed how mistaken identification can deprive someone of their constitutional rights. He noted very real concerns about racial disparities in the development of artificial intelligence and facial recognition tools. These tools have led to numerous erroneous arrests, mostly of people of color. For example, just over a year ago, a Detroit woman was arrested for robbery and carjacking after she was improperly identified as the perpetrator by an automatic facial recognition search. She was 8 months pregnant when she was arrested. After being held by the police for 11 hours, she was released on a $100,000 bond. It took a month and 2 hearings for the case against her to be dismissed. Under this bill, however, if this woman had been on DACA or TPS status, ICE would have been required to detain her upon her release, and her U.S. citizen son would have been born in immigration detention, even though she committed no crime. Mandatory detention of innocent people is not a reasonable or sensible policy choice. This is not where we should be focusing our limited enforcement resources. It is important to remember that this bill would subject more people to mandatory detention at a time when Republicans refuse to give the Department of Homeland Security the resources it needs to carry out its policies. The Biden administration is currently detaining 39,000 people a day. This is 5,000 more people than Congress has even provided funding for it to detain. Congress has never appropriated, and no administration has ever requested, sufficient resources to detain all non-citizens who fall under the mandatory detention categories. Even former President Trump never tried to detain all migrants subject to mandatory detention. House Republicans know this, but instead of facing that reality and providing the resources necessary to address weaknesses in the immigration system, they would prefer to demagogue the issue, and they bring us measures like this. If that weren't bad enough, this bill also purports to give state attorneys general standing to sue in court for perceived violations of certain sections of the Immigration and Nationality Act, hoping to convince the judicial branch to impose the draconian immigration policy preferences that MAGA Republicans have failed to get through the political branches of the federal government. This bill simply declares that states have standing to sue so long as the state or its residents suffer almost any degree of harm, no matter how trivial, appearing only to exclude financial harms that are less than $100. And we should note that this provision is almost certainly unconstitutional. Just declaring that there is standing does not make it so. Just last year, the Supreme Court addressed the issue of states standing to sue the federal government over immigration enforcement matters, which this bill appears to be a half-baked attempt to circumvent. In an 8-1 decision, the court held that Texas and Louisiana lacked Article III standing to bring suit against the federal government over its alleged violation of some of the very same immigration statutes that this bill would purport to grant standing to the states to sue over. In rejecting the state's standing argument, the court noted, among other things, that lawsuits alleging insufficient arrests or prosecution run against the executive branch's Article II authority to enforce the law, which includes the discretion to determine enforcement priorities in the face of lack of resources and shifting public safety and public welfare needs. This bill also goes directly against the Supreme Court's settled precedent in Spokio, Inc. versus Robbins, which explicitly states that a statutory right to sue does not constitute an injury for purposes of standing. But settled precedent, much like responsible governance, doesn't seem to matter much to the majority. Time and again, Republicans have refused to engage in bipartisan immigration reform. At the behest of Donald Trump, Republicans dismissed out of hand a bipartisan Senate border bill that Senate Minority Leader McConnell called the strongest border bill in 30 years. In October, the Biden administration sent Congress a supplemental funding request, which included an additional $14 billion for border security. House Republicans refused to schedule a vote on this funding request, which would provide the Biden administration the resources it needs to secure the border and would provide additional support for communities receiving migrants. Both these bills would have allowed the Biden administration to hire thousands more asylum officers and immigration judges, so asylum hearings happen in weeks, not years. This would help put an end to what my Republican colleagues refer to as catch and release, a procedure in immigration law that has been used by every administration for decades. All they can point to is H.R. 2, which last week got a grand total of 32 yes votes in the Senate when it was brought up for a vote. Instead of rushing yet another partisan stunt to the floor, the majority should work with Democrats to pass bipartisan solutions to address the situation at the border. That would be a far better way to truly honor the lives of those we have tragically lost. Thank you, and I'd be happy to answer any questions.
Thank you very much. Chair has no questions at this time.